Everyone knows that the purpose of estate planning is to pass your assets upon death, but there's another equally important purpose, too often overlooked, and that is to plan for incapacity. Now, I don't care if you're old, young, healthy, unhealthy. I've had clients in their 40s use these documents as well as clients in their 90s. At any given point in time, these incapacity documents could apply to any of us. There are two main incapacity documents that we're going to discuss today: a financial power of attorney and a medical directive. Let's start with a financial power of attorney. When I review an old estate plan, this is the document I see missing the most often. This document allows someone that you trust to step into your shoes financially. In other words, it allows them to access your accounts and pay your bills. It's important to determine when the power of attorney becomes effective. It could either be effective immediately, we call that a durable power of attorney, or effective only upon incapacity. We call that a springing power of attorney. Again, a durable power of attorney is effective immediately, meaning your agent can step into your shoes when they feel that you're in need of help. The upside of doing a durable power is that the agent can start helping right away without any hurdles. It's totally seamless. The downside is that the document could be used without your permission before proving incapacity. A springing power of attorney, on the other hand, becomes effective only upon proving incapacity. The upside is that there's protection there. The agent cannot act without first getting a doctor or multiple doctors, depending on how it's drafted, to sign off. I typically do durable powers of attorney. I've just seen too many cases where the child is the agent for the parent, but is unable to act in that role because the parent refuses to go to the doctor and get a doctor to sign off. Understand that with either of these documents, you as the principal can revoke them at any time. Also, regardless of whether you do a durable or springing power of attorney, I'm going to give you a few tips to make sure that the power of attorney does what you want and covers you in all situations. Tip number 1, it's better to have a robust and specific form than a short and generic form. A lot of powers of attorney that I review are 1 to 2 pages and state very generically that the person you're giving power to has all authority. The problem with making this form generic is that if the person goes in to use it at the bank, for example, the bank may not be comfortable letting the person withdraw tens of thousands of dollars based on a generic statement that they have all power. I've had multiple clients tell me that banks have rejected those types of forms because they did not see anything specific in the form talking about the bank. Tip number 2, have backup agents. When I look at forms drafted 20 years ago, they almost always name one agent, often a spouse, with no backups. We're drafting these forms to be forward-looking, and we need to take into account the fact that your spouse or partner, if any, is likely around your same age and could die or lose capacity before you. In all cases, we should have a younger backup. Tip number 3, having multiple agents can be a good option. I often get clients in their 50s and 60s who claim that a brother or sister acting as a power of attorney for a parent is not being forthright or is flat out stealing money. Is that the case? Well, hopefully not, but it's possible. How could we counteract this problem? By having multiple agents. The reason that you don't always see multiple agents in a power of attorney is because it can become impractical. If a person loses capacity and needs help over a long period of time, let's say 5 to 10 years, it may become impractical to have 2 people that have to sign off on every little thing. And that is why co-equal agents may be a good option as well. A co-equal agent is an and/or designation. It allows each agent to act independently, but also see what the other agent is doing. This cuts down on the potential for fraud. It also cuts down on the suspicion from the other kids involved, because now you have 2 siblings that can both see what's happening. Tip number 4, put the power of attorney on file with the institution where you intend to use it. A lot of clients don't understand that that is the purpose of a power of attorney. Instead, what they try to do is they make a child a joint owner of their account. This is a bad idea. It may work out in some instances, but it can also backfire. Here are 2 cases where I've seen it backfire. First, if you make a child a joint owner of the account, understand that that child will be the sole owner when you die. I don't care what the trust says. I don't care what your will says. If that child is a joint owner of the account when you die, they have no obligation to share that money. Even if they want to share the money, the moment that you die, that money vests in them, and there might be gift tax consequences if they want to share with siblings. Second, if your child is a joint owner on the account, that can open you up to liability. If that child, for example, is in a car accident, a creditor could go after that account. If that child is added to the account during their marriage and they're now getting divorced, that could be looked at as a marital asset and could be tied into their divorce. Tip number 5, institutions may want you to fill out their form. Understand that what a lawyer would do for you is a generic power of attorney, but each institution that you deal with has their own internal policies and forms that they may require you to fill out. For example, the Social Security Office will not allow you to help a family member unless you complete their power of attorney. Let's shift gears and talk about the necessary medical documents. This form is called a number of different things in a number of different states, but generally referred to as an advance directive, which includes a living will and a healthcare power of attorney. Let's talk about the two components of the advance directive, starting with the power of attorney. A medical power of attorney is a legal document in which you name an agent to make healthcare decisions for you in the event you're unable to make them for yourself. Before the power of attorney can be used, a physician would certify that you're unable to make those decisions. In a medical power of attorney, you would define the scope of your agent's authority. This would include things like whether your agent can check you into a nursing home, be your guardian, or donate your organs. The person you pick as an agent should be someone that you trust to carry out your wishes, someone that's comfortable asking questions and advocating on your behalf. The second component of the advance directive is the living will. A living will is a legal document used to state certain future healthcare decisions. This is used only when you're unable to make the decisions for yourself. In this document, you're describing the types of medical treatment you want or don't want to receive in certain situations. For example, if you were in a persistent vegetative state, would you want life-sustaining measures, such as food and fluid by tubes, antibiotics, CPR, or dialysis? These forms vary drastically from state to state, and there's only so many situations that they can cover. For that reason, a lot of clients let their agent decide. At the end of the day, talking to your agent about what you want is the most important thing that you can do. I would make sure that they understand and are willing to follow your wishes. An advance directive is a contract and should therefore be valid in most states within the United States. For all of you that spend multiple months in other locations, you could have a power of attorney in multiple states, but you do run the risk of the newest document being declared your most recent wishes and voiding out the old document. So if you're going to do this, you will want to make sure that the two forms match up as closely as possible. In most states, there is a default document that you can fill out. Now, you could have an attorney draft a totally separate, customizable document that doesn't go off of that state form, but I would advise against it. That being said, I hesitate to draft a unique advance directive for my clients and almost always use the state form, for the simple reason that I don't want medical staff unfamiliar with the document that we're using in the moment when it's being used. I don't want medical staff kicking it out to the legal department if they're unsure about interpreting the form. No discussion on healthcare documents would be complete without talking about the POLST form. POLST is an acronym for Physician Orders for Life-Sustaining Treatment. It's a set of specific medical orders that you can fill out with your physician. This form needs to be signed by your physician. Often this form is filled out when a patient has a very specific medical condition and often before a significant medical procedure. As you go through this form, you'll see that it's very specific. It allows you to designate whether to resuscitate if you're found without a pulse, or whether to use a defibrillator. It allows you to pick situations in which you want medical treatment, like intubation, medical ventilation, and other services, or when comfort measures should be taken and what those measures should be. POLST forms are available in most states. Today, we walk through the basic incapacity documents in an estate plan. If you have more specific questions or would like to get a financial power of attorney or advance directive in place, talk to a licensed attorney in the state where you reside.